Rolling over funds from an employer retirement savings plan. What you need to know. Why consider rollover? When you roll over a distribution from a 401k plan, a 403b, or governmental 457 plan, you generally don't pay any taxes until, of course, you receive distributions from a new plan or an IRA. If you take distribution but don't roll it over, it will be subject to federal and possibly state income taxes, except for any after-tax contributions that you've made. And if you haven't yet reached age 59 and a half, you may also be subject to a 10% early distribution penalty tax unless you're eligible for an exception. If you take a cash distribution, you're also foregoing any further tax advantage growth, of course. And if you spend the funds, you may not have sufficient assets to last through retirement. A side note to all this, special rules apply to distributions from a designated Roth accounts. Qualified distributions are entirely tax-free and only earnings are taxed if your distribution is non-qualified. A distribution is qualified if you satisfy a 5-year holding period and you're age 59 and a half, disabled, or use the funds to purchase your first home. It has a $10,000 lifetime cap. State tax rules may be different. Not all distributions are eligible to be rolled over. You cannot roll over hardship withdrawals, required minimum distributions, substantially equal periodic payments, corrective distributions, and certain other payments. Non-spousal death benefits can be rolled over only to an inherited IRA and only in a direct rollover. So let's talk about reasons to roll over to an IRA. You generally have more investment choices with an IRA than with an employer plan. You typically may freely move your money around among various investments offered by your IRA trustee, and you may divide your balance among as many of those investments as you want. By contrast, employer plans typically give you a limited menu of investments, usually mutual funds, from which to choose from. You can freely move your IRA dollars among different IRA trustees or custodians, unlike indirect 60-day rollover between IRAs, which are generally limited to one in any 12-month period. There is no limit on how many direct trustee-to-trustee IRA transfers you can do in a year, by the way. This gives you the flexibility to change trustees often if you're dissatisfied with an investment performance or customer service. It can also allow you to have an IRA account with more than one institution for added diversification. With an employer's plan, you cannot move the funds to a different trustee unless you leave your job and roll over the funds. An IRA may give you more flexibility with distributions. The distribution option available to you and your beneficiaries in an employer plan are typically more limited with an IRA. The timing and amount of distributions are generally at your discretion until you must start taking required minimum distribution, if that is applicable. If you've made a Roth IRA contribution to your 401k or a 403b plan, these distributions plus any investment earnings on them will be subject to required minimum distribution rules after you turn 72 or after you retire, if later. If you own 5% or less of your employer, you can avoid the RMD rules by rolling your Roth contribution over to a Roth IRA. Roth IRAs are not subject to the lifetime RMD rules. You can use individual retirement annuity to effectively annuitize all or part of your employer's plan benefit. This can help you if your plan doesn't provide an annuity option. Before investing in a mutual fund, carefully consider the investment objectives, risks, charges, and expenses of the fund. This information can be found in the prospectus, which can be obtained from the fund itself. Read it carefully before investing. Diversification alone cannot guarantee profits or ensure against possibility of a loss. All investing involves risk, including the potential of loss of principal, and there can be no guarantee that any strategy will be successful. Reasons to leave or roll over to an employer retirement plan. Many employer-sponsored plans have loan provisions. If you roll over your retirement funds to a new employer plan that permits loans, you can generally borrow against your vested balance in the new plan, including the amount rolled over. If you need money, you cannot borrow from an IRA. You can only access the money in an IRA by taking distribution, which may be subject to income tax and penalties. A rollover to another employer plan may provide greater creditor protection than a rollover to an IRA. Most qualified employer plans, like 401k plans, receive virtually unlimited protection from creditors under the federal law. Your creditors cannot attach your plan fund to satisfy any of your debts and obligations, regardless of whether you declared bankruptcy or not. In contrast, traditional and Roth IRAs are generally protected under federal law only if you declare bankruptcy. Any creditor protection your IRA may receive in cases outside bankruptcy will generally depend on the laws of your particular state. If you're concerned about asset protection, be sure to seek the assistance of a qualified professional. Special rules apply to individuals, solo 401k plans, governmental plans, and certain church plans. Distribution from your employer plan won't be subject to the 10% early distribution penalty if you retire during the year you turn 55 or later. Age 50 for qualified public public safety employees. However, distributions from your IRA before you reach age 59 and a half will be subject to penalty tax unless an exception applies to you. You may be able to postpone any required minimum distribution. These distributions usually must begin no later than April 1st following the year you reach age 72. However, if you work past that age, you're still participating in your employer's retirement plan and own no more than 5% of the company. You can delay your first distribution from that plan until April 1st following the year of your retirement. While IRAs typically provide more investment choices than any employer plan, there may be certain investment opportunities in your particular plan that you cannot replicate with an IRA. Further, you may be satisfied with the potentially lower cost funds available in your particular plan, and therefore may not regard an IRA's broader array of investment as an important factor for you. Other considerations. Both employer retirement plans and IRAs typically have investment-related expenses and plan or account fees. Investment-related expenses may include sales loads, commissions, the expenses of any mutual fund which assets are invested, and investment advisory fees. Plan fees typically include plan administrative fees, example, record keeping, compliance, trustee fees, and fees of services such as access to a customer service representative. In some cases, employers pay for some of or all of the plan administrative expenses. And IRA fees may include, for example, administrative account setup and custodial fees, so be sure to carefully consider the expenses and the fees in each alternative. Also, be sure to consider the different levels of services available under the employer's plan versus an IRA. Some employer plans, for example, provide access to investment advice, planning tools, telephone helplines, educational material, and workshops. Similarly, IRA provide other different levels of service, which may include full brokerage service, investment advice, distribution planning, and access to securities and execution online. Special considerations for distributions from a designated Roth accounts. In order to receive a tax-free qualified distribution of earnings from a Roth IRA or from a designated Roth 401k, 403b, or 457b account, you must satisfy a 5-year holding period. Separate 5-year holding periods apply to designated Roth account and Roth IRAs. If you receive an unqualified distribution from a designated Roth account and roll it over to a Roth IRA, the investment earnings rolled over will then be subject to a Roth IRA 5-year holding period. So, for example, if your money has been in a designated Roth account for 4 years and you roll those dollars into the first Roth IRA, they'll be subject to a new 5-year holding period. The amount of time those dollars spent in the 401k plan does not affect your Roth IRA holding period. On the other hand, if you receive a distribution from your designated Roth account and roll it over into a designated Roth account in a new employer 401k or 403b or 457b plan, your 5-year holding period in the receiving plan for both the amount rolled over and other funds in the receiving plan will be the 5-year holding period in the distributing plan or the 5-year holding period in the receiving plan, whichever ends first. That is, whichever is more favorable to you. Required minimum distributions are generally required from Roth 401k and 403b accounts after you turn 72 or after you retire, if later, unless you're 5% owner. However, Roth IRAs are not subject to the lifetime RMD rules. You can avoid the Roth 401k 403b lifetime RMD rules. To learn more about rollover options, we have a webinar on 6 rollover options and its pros and cons. Many mistakenly think that a rollover is an easy choice, but that's rarely the case. Depending on your particular situation, you may have up to 6 different options to choose from. This webinar will also shed some light on some common mistakes so that hopefully you can avoid them. The link to the webinar is in the description.